Good morning. Today we are with another chapter of our Cdcs examination syllabus, and that is on the sales contract. Let's see what is the sales contract. We know that it is always between an applicant and a beneficiary, the buyer and the seller. So the sales contract, what is our learning objective today? In this chapter we will be talking about the importance of the sales contract. It emphasizes the need for the buyer and the seller to agree upon specific data elements. They have to agree upon specific data elements that will enable the shipment of the goods, provision of services or performance, creation, presentation of appropriate documents. So all these have to be agreed in the sales contract. The presentation of document, the shipment period, the payment terms, all these data elements have to be discussed in the sales contract. It will also provide for an agreement how the seller will be paid for those goods or services or performance. So let's see what is learning objective, how we are going to take it out. The most basic agreement in international trade is the sales contract. So in any international trade, what is the most basic element? It is the sales contract concluded between the seller and the buyer. Now sales contract is also known as sales agreement or export contract or a foreign sales agreement, because this is usually in international trade. So it is also known as a sales agreement or an export contract or a foreign sales agreement. So all other agreements and procedures which are commonly used in international trade result from the performance of the sale contract. So from where do they result from? The performance of this sale contract. Example, what are the two essential components of a sale contract? One, seller's agreement to provide the goods to the buyer. What is the seller's agreement? To provide the goods to the buyer. What is the buyer's agreement? To pay at a specified price in return. The buyer's agreement is to pay at a specified price in return. So, in the context of a cross-border transaction, the first of these, that is the seller to ship the goods, it usually involves conclusion of a contract with a carrier to transport the goods from the country in which the seller is located to the country where the buyer is located. So the buyer's agreement makes it necessary to arrange payment. How does the buyer arrange payment? Through the banking system. So these are the two important points which we will be talking about in the sales contract. The conclusion of a contract with a carrier to transport the goods from the country in which the seller is located to the country in which the buyer is located. Second point comes with the buyer. The buyer's agreement makes it necessary for arranging the payment through the banking system. So let's see how it happens. So this is the introduction for the sales contract. Other procedures related for sales and payment can be government requirements, sanctions, customs procedures, exchange control regulations. All these are the other things that take place. Government regulations such as customs procedures, exchange control regulations. So a documentary credit is now chosen as a method of settlement. And we all know that a sale contract is separate from the documentary credit, because credit is always between the issuing bank and the beneficiary. So contract is separate. Many sales contracts are made between a seller and a buyer. Sometimes they are located in the same country also. In these circumstances, the laws of that country will govern the contract's execution, any disputes that might arise. If they both are located in the same country, then it will govern the contract execution. Any dispute that might arise, it will pertain to the laws of that country. If they are both in the same place they are located. For a cross-border transaction, the situation is different, because the seller is in one country, the buyer is in another country. So there is no general system of international commercial law. There is no general system of international commercial law that covers such contracts in cross-border situations. This means that execution of a sales contract is likely to be governed by provisions that will differ from one country to another country. There is no general system of international commercial law. So what happens? We have to be governed by provisions pertaining to that country that differ from one country to another. So it will reflect what? It will reflect different commercial laws. So the situation provides significant scope for uncertainty. So definitely when the laws are differing from country to country, there will be uncertainty whenever there is a dispute between the seller and the buyer. So resolving such disputes may be time consuming. So in order to resolve such disputes, it may be time consuming, it may be very costly. Especially if they are resolved in a court. Especially if the disputes go to a court or via arbitration. So in extreme cases, sales contracts can be deemed null and void, consequent loss for both the parties. Because there is no general system governing the law, commercial law. It differs from country to country. So this confusion makes it vital that a seller and a buyer reach an agreement. That is why when the seller and the buyer enter into a contract, they have to reach an agreement so that in order to avoid the disputes that might arise at a later stage. Banks play no role in the negotiation of the sales contract. We are not concerned with the sales contract because it is signed only by the seller and the buyer. Sales contract is signed only by the seller and the buyer. As a banker, I am not concerned with the sales contract. So, the key element of any sales contract is agreement of the buyer to pay the seller an agreed price for a specified quantity of goods. In many countries, this simple agreement is sufficient to constitute an import-export contract. So, an import-export contract, what is the simple agreement? Agreement of the buyer to pay the seller at an agreed price for a specified quantity of goods. So that is the key element of a sales contract. In other words, the contract does not need to be a lengthy formal document to be legally enforceable. So in order to be legally enforceable, the contract need not be a lengthy document. Contracts also do not need to be formally notarized. Even contracts need not be formally notarized. An agreement can be reached in a telephonic conversation or via an email or a fax message. So contract agreement can be reached very simple methods: telephone, email or a fax message. So this is a contract, can you see? This is a contract for the sale of goods. This is given in our textbook and this is how the contract is signed. You can just have it, read it from your textbook. So in practice, a sales contract will contain more detail. Sales contract will have more detail than only quantity of goods. So it is not only quantity of goods or it is not only sale price. There will be something more. It will relate to time period for delivery, when the goods have to be delivered, method of payment, whether it is signed, deferred, acceptance, negotiation, manner in which the goods are to be delivered. So there will be a trade term, that is the import term, how the goods are to be delivered. So other than quantity of goods and sale price, the sale contract will also have these elements. Which are the elements in a sale contract? Time period for delivery, method of payment, manner in which the goods are to be delivered, that is usually associated with the trade term, that is the import term. So some contracts will also specify which country's law will apply. Some contracts will also specify that. Which court or arbitration system, which jurisdiction, in case there are any claims, disputes, all this have to be very clearly marked marked in a sales contract. So, country's law, court or arbitration system. So, a sales contract, a seller instead of a sales contract, sometimes he will send to the buyer a pro forma invoice. It will contain all the details of the goods, the unit price, before the transaction is concluded. So, before the transaction is concluded, the seller will send a pro forma invoice rather than a sales contract. Similarly, a buyer may send the seller a purchase order. So, the seller will be sending a pro forma invoice, the buyer will be sending a purchase order, confirming that the buyer has given a commitment. The buyer has given a commitment to purchase certain goods at an agreed price on specified terms. To purchase certain goods at an agreed price on specified terms. So, this is a pro forma invoice. It is also given in the textbook. You can read it in the textbook. The pro forma invoice can be read in the textbook. Now, this is also a pro forma invoice. It can be read in the textbook. A purchase order, sorry. Pro forma invoice is given by the seller. Purchase order is given by the buyer. This can be read in the textbook. So, sales contract are usually agreed between a seller and buyer in the normal course of business rather than private individuals. Many sellers and buyers have their own standard conditions of sale and purchase. They will set out the terms on which they normally conduct their business. This will be included by reference in a sales contract. They will include a reference in a sales contract. Problems can arise because there may be some differences between the standard terms of the seller and the buyer. So, the two parties may well exchange these standard terms. So, in a pre-contract negotiation, it is good if the seller and the buyer exchange these standard terms. Because if differences are not resolved at this stage, problems can arise later if there is a dispute. Because it is difficult to set all the conditions. So, at least before the negotiation takes place, the problems can be resolved. In extreme cases, then the dispute will be having to take you to a court or a tribunal. In extreme cases, dispute will be taken to a court or tribunal, where a judge will be there or arbitrator will be there. They might decide that no contract was ever concluded because the seller and buyer did not agree on the applicable conditions. Seller and buyer did not agree on the applicable conditions. So, there was no contract. Judge or arbitrator may decide. So, a judge or arbitrator will try to seek a resolution by determining one or other set of conditions or both sets of conditions to wherever there is a conflict. In most cases, sales contracts are governed by the laws of a country in which one of the parties is located. The law governing the contract. In most cases, sales contracts are governed at least in part by the law of the country in which one of the parties are involved, located. Seller and the buyer may agree which law is to apply. So, usually seller and buyer will agree which law is to apply. There will be a specific provision in the sales contract which law is to be applied, which law is the law governing the contract. If there is no such agreement or provision, then in the event of a dispute, a judge or arbitrator may first have to determine which is the governing law. So, they will have to first look into the governing law, if any law is not prescribed. In these circumstances, a judge or arbitrator will often decide to apply the law of the country most connected with the contract, which may be the country to which the goods are being delivered. Usually, the law may be of the country where the goods are being delivered, that is the importer's country. The use of trade terms, example, if it is cost, insurance and freight, or if it is free on board. So, when does the seller fulfill his obligation? When the goods are loaded on board at a ship. They are loaded on board a ship at the named port of loading. At the named port of loading. So, this is a like this we use in-quote terms, which we will be doing now, the 11 in-quote terms. It can be CIF, FOB. Here in both these cases, the seller will fulfill his obligation when the goods are loaded on board a ship at the named port of loading. At the named port of loading. So, there have been a number of attempts to introduce an international law for export sales. The latest is, there are a number of laws they are trying to introduce, and the latest is United Nations Convention on Contracts for International Sale of Goods. This is the law. Which is the latest law? United Nations Convention on Contracts for International Sale of Goods. This is called as CISG. CISG. C means Convention on Contract for International, I is International, SG, Sale of Goods. Sale of Goods. So, Convention on International Sale of Goods. This is a contract. Convention on Contracts for International Sale of Goods. United Nations Convention. Contracts for CISG. Contracts for International Sale of Goods. Contracts for International Sale of Goods. This was signed on 11th April 1988 Vienna, and it came into force on January 1988 after 8 years. And after being ratified by 11 countries, the CISG provides a standardized set of legal rules for import-export transaction, and as of July 2015, 83 countries had ratified the convention. How many countries had ratified the convention? 83 countries as of July 2015. So, CISG provides a standardized set of legal rules for import-export transactions, and it was signed on 11th April 1980 in Vienna, came into force on January 1988. In addition to determining the quantity of gold, any unit price, what is the checklist? What is the checklist for an effective sales agreement? Seller and buyer should agree to minimize the risk of dispute. So, they have to apply the appropriate in-quote term. So, the terms of delivery of the goods, the point at which the risk in the respect of good passes from seller to buyer, where the risk passes from seller to buyer, who should clear the goods through customs, and where, who arranges for insurance for the carriage of goods, up to what point. What precise risks to the goods need to be covered, specifically shown as covered on the insurance document. What commercial documents are needed, what should be shown on them. Whether any other document such as inspection certificates are needed, who is to issue them. All these have to be discussed in a sales contract. Then the sales contract, having agreed, the method of settlement is also important. Sales contract should be specific in describing the payment terms, the type of documentary credit that is required, Settlement by irrevocable documentary credit, settlement by documentary credit, payable at site, payable at 60 days after the date of shipment. So we have to be very careful. It should not be very imprecise. It should be precise. So seller is always looking at goods on a site basis. So with the expectation of full payment, less normal bank charges. Once a seller makes a compliant presentation to a nominated bank, seller is always looking for payment on a site basis. So it is not sufficient to state payment by documentary credit at site. It is not sufficient. So the buyer, as an applicant, he may arrange for issuance available by negotiation on a site basis. Therefore, it will meet the condition of a sales contract, site documentary credit. But the outcome will be the seller requires immediate settlement and there is a compliant presentation for the period between the nominated bank effecting settlement, issuing bank providing the nominated bank with reimbursement. So this is very important which settlement method is to be taken. So a seller who is requiring immediate settlement without deduction of interest will always say documentary credit payable with his preferred bank by payment. So in this sales contract we have studied the seller and the buyer entering into a contract and all the terms and conditions being discussed in the sales contract, or sometimes the seller sends a pro forma invoice and the buyer issues a purchase order in order to see how the sales contract is effective, and the law governing the contract, the payment terms, all these have to be considered when the seller and the buyer conclude a sales contract, and everything has to be settled within a pre-negotiation stage in order to avoid the dispute at a later stage. Now we will be talking about the Incoterms. Thank you.